The outcome of the Clinton investigation by the FBI and Department of Justice was determined by September 2015. That's just a few weeks after the investigation began and at least 10 months before the decision was announced.
Although there is evidence of potential violations of the statutes regarding the handling of classified information, our judgment is that no reasonable prosecutor would bring such a case.
While Comey drew intense criticism for that conclusion, it was the Justice Department that tipped the scales in Clinton's favor, virtually assuring she wouldn't be charged. DOJ did so with a secret legal interpretation made sometime in July or August 2015 by one or more unnamed officials. The IG's report describes the legal framework for the case in a footnote on page 164. That footnote references 18 U.S.C. 793F of the Espionage Act. The law does not require a proof of intent to find someone guilty of mishandling classified information. But the IG report states prosecutors told us that the Justice Department interpreted the provision to require the accused possess knowledge that the information is classified, and that the conduct must be so gross as to almost suggest deliberate intention. That burdensome legal threshold was impossible to meet, and that was by design. Prosecutors needed a smoking gun text or email to prove intent. They found neither. The IG report states, by September 2015, FBI and Justice Department officials realized that they were unlikely to find evidence of intent.
It sadly confirms that even though Hillary Clinton should have been charged with mishandling classified information, she was never really in danger of seeing that happen.
I thought it was rigged from the beginning. I really think that once President Obama, in particular, laid out what I think is a contorted construction of the Espionage Act statute, which is what they investigated her under.
DOJ's tortured misreading of the law was concocted to ensure Clinton wouldn't be charged.
And he laid out a theory of the Espionage Act that I don't think can be justified by reading the act, and everybody just acted accordingly.
Here's how Comey explained it at congressional hearings in 2016.
Really, the central problem we had with the whole email investigation was proving that people knew, the secretary and others knew that they were doing something, that they were communicating about classified information in a way that they shouldn't be, and proving that they had some sense that they were doing something unlawful. That was our burden, and we weren't able to meet it.
The fact is, proving intent is not required.
Your earlier clip with Mr. Comey talking about intent is a fraud. There's no requirement for proving intent. It's a direct violation of Title 18 of the U.S. Code, Section 793F, which is mishandling national defense information. Intent is irrelevant. The fact that the loss or the mishandling of the national defense information occurred, that's the crime.
The IG's report also addressed classification markings, another of Clinton's defenses.
I never sent or received anything that was marked classified. I will reiterate, because it's a fact, nothing I sent or received was marked classified.
Secretary Clinton said there was nothing marked classified on her emails either sent or received. Was that true?
That's not true. There were a small number of portion markings on, I think, 3 of the documents.
Under law, classified information is classified whether marked or not. However, prosecutors did not fault Clinton because none of the emails contained clear classification markings. Yet even Comey admitted in his press briefing that's not an excuse.
Even if information is not marked classified in an email, participants who know or should know that the subject matter is classified are still obligated to protect it.
Clinton vowed to protect it the day after being sworn in when she signed this federal non-disclosure agreement. It states classified information may be marked or unmarked.
The espionage statutes and the gross negligence statutes say nothing about the labels on a piece of paper or an email. What matters is the substance of the information in the communication.
It's absolutely irrelevant whether or not something is marked classified.
Right.
It's the character of the information.
Let's go back to that footnote on page 164. The Justice Department decided they needed to prove Clinton knew the information was classified. The FBI's 302 summary of its Clinton interview reveals she did not recognize classified material or markings in her own email. Was she really that dumb, or just playing dumb to avoid prosecution? the FBI decided she's really that dumb. Page 137 states, Comey told us that the agents that conducted the interview found her credible and were surprised at how technically illiterate she was. The result? Clinton got away with mishandling classified information in hundreds of emails.
That's a very serious matter, and it should have compelled a serious investigation. And yet the IG report confirms that exactly the opposite happened. A very light touch where Hillary Clinton got preferential treatment.
In fact, DOJ prosecutors went so easy on Clinton that FBI Director Comey called them cowards during his interview with the IG. He told the IG there was a general lack of aggressiveness that wasn't politically motivated, just normal cowardice in high-profile cases. More about that and how the DOJ limited the FBI investigation in our next report. This is John Spiropoulos reporting.